check. This thing on. That's right, ladies and gentlemen, we're live tonight. I had a little snafu getting things uploaded, and instead of fighting with YouTube to get things uploaded, I decided we're just gonna do this thing live. We're gonna do it live like we've never done it before. And ladies and gentlemen, we've got a docket full. We're gonna be starting off with a saga, a full saga with Judge DiSanto that begins in September and ends in October. And then we're going on to our anti-harassment docket that we always watch on Mondays with Judge Meyer. Then I have a crazy landlord-tenant case with Judge Middleton that you just got to see to believe. And then we'll wrap things up a little bit of Judge Simpson because, you know, I just love Judge Simpson, and why not? It's a great way to end the day. Ladies and gentlemen, welcome to a very unique Monday Lone Wolf Live from the gallery, and you know how it starts. It starts right now. Thank you so much, Rhonda. Thank you to everybody. Thank you to everybody who's coming out. You are all amazing. You all rock. I love you all. Let's get to watching some court, shall we?
Let's go on the record in the matter of the state of Michigan versus Samuel Juguna, 251234.
Good morning, Your Honor. Jonathan Simon, P35596 for Mr. Juguna.
Thank you. Mr. Juguna, your name for the record, please. You're muted, sir.
Samuel Juguna, Your Honor.
Okay. I don't even have a sheet in here from the prosecutor for today. Counsel, what's happening today? You had an opportunity to speak to the prosecuting attorney.
No, I was in the waiting room for about 2 hours, and then I received a message to return to the courtroom.
Right. There was a time that he was out of the office because he was in chambers, but okay, we're going to recall this matter. Let's put Mr. Simon back in the breakout room with the prosecutor. Thank you. Let's go on the record. Let's go on the record in the matter of I still don't have anything in here. Let's go off the record here. I don't have any, there's nothing in here. Poor Mohammed, he's also, him and Johnny G are all over the place today. Mr. Simon, I don't have the document. Well, let's go on the record in the matter of the state of Michigan versus Samuel Juguna, 251234. I just need the plea form.
The plea form.
Yeah. And Mr. Simon,
Jonathan Simon, P35596 for Mr. Juguna. Your Honor, Mr. Mohammed has made an offer which I would like to share with my client. I did text him, but I didn't receive a response, so perhaps I could have a brief breakout with him.
You sure can. We'll go off the record. We'll put the two of you in a breakout room.
Thank you.
Thank you. Okay. We are on, well, hey, maybe the fourth time we call it's charm. We're back on the record in the matter of the state of Michigan versus Samuel Juguna, 251234. So
Fourth time. Good afternoon, Your Honor. Jonathan Simon, P35596 for Mr. Juguna.
Okay, thank you. And Mr. Juguna, if you can please unmute. If you can please unmute, sir, and then please state your name for the record.
Samuel Juguna, Your Honor. Sorry about that.
Okay, thank you. I do apologize, sir. I know you've been here for a bit and there's a lot of moving parts today. Okay, so counsel, today's the date scheduled for the adjourned probable cause conference.
Yes, if I may voir dire my client, Your Honor. Sir, you do understand you're charged with a 5-year felony carrying a concealed weapon in a motor vehicle, correct?
Hold on,
Yes.
counsel. Pause. What would the voir dire be for? Because I'm showing that you're setting it for an exam.
Right. I just want to make sure that this is what he wants.
Okay, all right. I just want to make sure that I had the proper paperwork and that you weren't trying to voir dire for a plea of some sort. So I just wanted to make sure we're all on the same page. You may continue.
Thank you. You do understand that, sir, do you not?
Yes, sir.
Okay. And the matter can be set for a preliminary examination, at which time the people would have to prove probable cause to believe a crime was committed and probable cause to believe you're involved in the commission of that crime, right?
Yes, sir.
Okay. You also know and understand that there has been an offer made, which would be this crime of transportation or possession.
Counsel, you don't, well, okay. I don't need to be privy to the plea. But if you want to make a record for your purposes, then you can certainly do that.
Okay. I'm a little confused. I mean, I understand that. Okay. So, sir, do you understand that there's been an offer for a 90-day misdemeanor? Well, actually, either 90 days or $100 or both for transportation of a firearm in a motor vehicle?
Yes, sir.
Okay. And it's my understanding you wish to reject that offer and proceed to the preliminary examination as to the felony carrying a concealed weapon in a motor vehicle.
Yes, sir.
Okay. Very well. Judge, I've made my record. I'm ready to schedule the matter for preliminary examination.
Okay. And counsel, I apologize. I did not intend to interrupt you. I just wanted to make sure that because I'm not, I don't need to be a participant in your plea negotiations, but I understand that you wanted to make a record for that. But I wanted it to also be clear that it wasn't for this court's knowledge purposes, but more so for a record for yourself.
Yes, consistent with the Supreme Court case Lafler versus Cooper.
Yes, very good. All right. So the court will schedule this matter for preliminary examination. Time has already been waived on September 4th. Does September 16th work for you, counsel?
I'm sorry, what month? December, you say?
No. Oh, I think I said September. I mean October. October 16th. No.
October 16th.
Wow. Disregard. Just one moment, because I have 2 bench trials that day. Do we already have any exams set that day in the morning? Oh, no, wait. What time are our bench trials? We want to set this for 2:30?
2:30 on the 16th?
I'm asking my boss over here. We'll go 2:30. October 16th at 2:30.
Very well. Thank you, Judge.
And any witness and exhibit list by October 13th. And that's in person, just so everybody's clear.
Yes, Your Honor.
Bond and conditions are continued, and we will see you then.
Very well.
All right, thank you.
Thank you.
All right, we will go on the record in the matter of the State of Michigan versus Samuel Juguna, 251234.
Good afternoon, Your Honor. Jonathan Simon, P 35596, on behalf of Mr. Juguna.
Thank you. And Mr. Juguna, your name, please, for the record.
Samuel Juguna, Your Honor.
Okay. And today is the date scheduled for the preliminary examination in council?
Your Honor, I believe we resolved this matter by way of a plea to a proper transport.
All right. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
And you heard the plea that your attorney placed on the record, correct?
Yes.
As to the amended charge of improper transport of a firearm, how do you plead?
Guilty, Your Honor.
You've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes, Your Honor.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes, Your Honor.
You understand the possible penalty as a result of your plea,
Sure.
whether in this court, any other court, or administrative agency.
Yes, Your Honor.
And specifically, in this situation, in the event that you do have a CPL or you're wanting to get a CPL, you understand that this could impact that.
Yes.
You also understand that there's a stipulation that you're going to forfeit the firearm and the ammunition, correct?
Yes, Your Honor.
And the stipulation also that you're not to possess any other firearms or ammo while you're on probation.
Yes, Your Honor.
And then other terms set by the court. Do you understand that?
Yeah.
Knowing all of that, do you want to continue with your plea? Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
Any immigration issues?
No, Your Honor.
All right, counsel, if you can please order your client.
Sir, on or about, August 23rd, 2025, were you in the city of Wyandotte, specifically in the area of Goddard Road and 13th Street?
Yes.
Were you in a motor vehicle?
Yes.
Okay, and you were stopped by the police
Yes.
and you had, you had a fire, the vehicle?
Yes.
Okay,
I
and
need you to speak up a little bit, please. They're having a hard time hearing you.
you had a firearm in the vehicle?
Yes, sir.
Okay, and was that, how was it transported?
He was in the back.
I can't hear you, sir.
He was in the back of the car.
Okay,
Okay.
and it was, loaded, it had bullets, it was loaded,
It was not loaded.
it was not, but it was, within your wingspan?
Yes.
correct? Nothing for this.
All right, and you do not have authority to transport that firearm, correct?
I don't understand the question, Your Honor.
You did not have a concealed pistol
No,
license
Your
in your,
Honor.
Okay. I should clarify legal authority. I apologize. All right, the court does find the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement, and counsel, you're going to go over to probation. You can, so you can coordinate your the sentencing date with probation, and then your client will also receive a date to return for his PSI and some paperwork to complete for his PSI.
thank you, Judge.
Okay.
May the, sentencing be conducted by Zoom?
It depends on what day. So if you end up selecting a Tuesday, then the court will allow that to be via Zoom, but not any other days of the week.
We can do it on.
Okay.
Thank you.
All right. Thank you for dressing appropriately for court, sir, and we'll see you back on sentencing date. Thank you. We are on the record in the matter of the state of Michigan versus Samuel Juguna, 251234. And counsel, your appearance, please.
Your Honor, Jonathan Simon, P 35596 on behalf of Mr. Laguna.
All right. Thank you. And Mr. Juguna, if you can please unmute and state your name for the record.
Samuel Juguna, Your Honor.
Okay, thank you. And counsel, today is the date scheduled for sentencing in this matter. Your client was originally charged with carrying concealed weapon, and by way of resolution between counsel was amended to improper possession of a firearm. I'm sorry, improper transport of a firearm. And counsel, did you have an opportunity to review the report and recommendation with your client?
Yes, Your Honor.
And are there any corrections that need to be made to the PSI?
No, Your Honor.
All right. And what would you like the court to know regarding your client, regarding any allocution?
Judge, the report is accurate, speaks for itself. He is a resident of the city of Wyandotte. He has a family. He took advantage of a good offer because he thought that the vehicle, the weapon was properly stored. It was not. He has learned from this, and when he hopefully will soon be able to obtain and properly carry a firearm in the future, we would ask the court to adopt the recommendation, which would be We asked the court to sentence him to the 4 days time served and to perhaps allow him maybe 30 days to pay any fines and costs assessed by the court.
So counsel, let me get this straight. You are asking for this court to sentence your client to 4 days jail, credit for 4 days, fines and costs only on a matter involving a firearm that was reduced from a felony to a misdemeanor. When your client previously had a reckless use of a firearm reduced to a disorderly person back in 2021. Is that what you're telling this court?
Yes, Your Honor. I believe that would be consistent with the probation department's recommendation.
Probation department's recommendation was incarceration of fines and costs. And so you believe that 4 days incarceration is sufficient for your client?
Yes, Your
With the
Honor.
history?
I do.
Your client's CPL was revoked in 2022, presumably as a result of the 2021 matter. And yet your client had a black handgun with a loaded magazine in the same location as the handgun within reach of your client in the vehicle. Your client doesn't have the right to possess a gun concealed because his CPL was revoked as a result of his prior issue.
But it was suspended. I thought it
Either
was
way,
suspended.
sir, you don't have, whether it's revoked or suspended, you don't have the privilege to carry a pistol concealed, which is what happened here.
Understand.
I'm not sure, sir, why you feel the need to carry a handgun.
I don't feel the
Conceal.
need to do it right now. It's just in the future. It was just one of those days. I had my life threatened a few years ago. I have police reports about that. And I was transporting it from Detroit to my house from working overnight. I was working till almost 2 o'clock in the morning, and I was so tired. I forgot it was the way it was. But I usually don't even need a weapon. I don't even carry a weapon since the last time in 2021. I only kept
Well,
it in.
except for August 23rd of 25.
Yes, ma'am, you're right. You're correct. It's just that day I was working so late in a bad neighborhood, and I had it in my tool packages. I don't know why I didn't consider leaving it either at the shop or thinking more than, taking a few minutes to think. It was just so late in the morning, so tired. I had about 14 hours worth of work in
It's
me.
even more reason why you should have possession of a handgun. If you're that tired and you can't properly put your thoughts together, you seriously should not be having possession of a firearm.
Your Honor.
Improper transportation of a firearm, counsel, is up to 1 year in jail. And you think that 4 days is sufficient given your client's background?
Yes, Your Honor. There were some extenuating circumstances. I do believe that this is a situation that occurred by accident for which he has deep regret, and I don't believe it's something which will recur again.
Counsel, it did not occur by accident. Your client did not accidentally carry a gun. Your client purposely and knowingly carried a gun because he wanted to have it for protection. Given your client's CPL status as being revoked or suspended, whichever one that it is, the report says revoked based upon a lookup, your client says suspended. In any event, your client doesn't have the authority to conceal a pistol.
Agreed.
He doesn't have that privilege. He knowingly and purposely carried that gun. He didn't accidentally carry the gun.
If I would have known, Your Honor, by the grace of God, I would have never had that gun in the car.
What do you mean if you would have known?
It was
If you would have known what, sir?
It was just an isolated incident. I don't even carry a gun in the car. Like I said, it was 2 o'clock in the morning and I was so tired, and I apologized to the courthouse.
Sir, I'm really not understanding your thought process. You're telling this court that you carried the gun because you were working late in a very, very bad neighborhood.
No, the gun was already at the location because that's where my tools are. But when I was loading everything up, the reason I'm saying it was accidental is I was not thinking what I was loading in the car. The car has so much stuff in it. I was going on vacation the next day. That's why I was bringing everything from the shop to the house, but I don't even carry it. Everything was in my tools. So I wasn't paying attention to what I was loading and unloading. It was so much junk in the car. Even the officer knows the car was just full of tools, full of stuff everywhere. And it's my mistake, Your Honor. I'm not sitting here trying to justify it.
Well, where were you working that day, sir?
It was West Warren and Epworth, which is about 2 blocks where my car was riddled with bullets a few years back.
West Warren and what street?
Epworth. E-P-W-O-T, Epworth. W-O-R-T-H. West Warren and Epworth. And the police record shows where my car had probably shot about 20 times right down the street because I worked at that shop for a long time.
And what shop was that, sir?
It's Earl's Auto Service, formerly Chuck's.
Okay. And so how long have you been working at Muffler Man in Taylor?
I've been there for 6 months. I don't work downtown anymore. I don't go to Detroit anymore.
Mr. Simon, are you on the phone while we're on the record?
No, Your Honor. I had to take a call from the Michigan Court of Appeals. They want to know why I haven't zoomed in yet for my 10 o'clock oral argument.
Okay, Mr. Simon, I just asked if you were on the phone while we were on the record, and you said no. You were clearly on the phone. You just answered the phone call. So if you have oral arguments right now, I was told that it was after 10 o'clock that you had oral arguments.
Yeah, I have 3 oral arguments at 10 o'clock in the Lansing Court of Appeals.
Okay, well, that's in just a couple moments. How long is that going to take, counsel?
I'm number 2, 3, and 4, so I'll be done hopefully before 11 o'clock.
Okay. Well, here's what I'm going to do, counsel, because the court is inclined to sentence your client to jail. So if you'd like, I will adjourn this matter 1 week.
Thank you.
So your client can get his affairs in order, and then you can get to your oral arguments.
Thank you, Your Honor.
December 9th.
Your Honor, on the 9th, I have oral arguments and a trial in Wayne Circuit Court. Can we go the 16th?
We can do the 15th, or I can do the 8th, or the 10th.
8th or the 15th. Yeah, either the 8th or the 15th.
Okay, we'll do December 8th at
I have a
11
9:30
a.m.
preliminary exam. Yeah, 11:30. I'm sorry, you say 11 or 11:30?
11. Oh, I can do 11:30.
11:30 is fine. I'm sure
Yes.
that will be well done by then with my 9:30 exam.
Okay, that's in person. Well, actually, that's in person. December 8th is in person.
Yes, Your Honor.
Okay, we'll see you back then. Thank you. Have a good day.
Take care.
All right,
Thank
off
you.
the record. And then let's go on the record in the matter of the State of Michigan versus Samuel Juguna, 251234. Good morning.
5596
Okay, you're very quiet. Is he coming through? Okay, if you could try it again and directly into the microphone, please.
Jonathan Simon, P 355-964, Mr. Juguna, who is present and standing to my right.
Thank you. And your name, please, sir.
Mr. Samuel Juguna, Your Honor.
Okay, and thank you for dressing appropriately for court. And the court will note that this is adjourned from last week because Mr. Simon had a matter in the Court of Appeals he had to get to. Court will also note that Mr. Simon answered the phone while we were on the record, counsel. That is not appropriate nor acceptable in this court, whether you're on Zoom, in person, or otherwise. When you're on Zoom, you're still in court. You can't answer a phone in the courtroom. Don't do it on Zoom.
Understood, Your Honor. It was from the Court of Appeals. They were looking for me, and quite frankly, they wanted to know why I had not yet zoomed in, and I apologize for taking the call, but it was necessary for me to let them know that I would be there shortly.
Counsel, we were on the record in your case. If you would have been standing in front of me, would you have answered the phone?
No,
No. Zoom is a privilege and an accommodation this court affords to individuals. It doesn't mean that it's any less of a decorum or professionalism if somebody's on court on Zoom.
yes, Your Honor. I did mute the Zoom, and perhaps I should have called them back, but it was kind of an emergency. But I do apologize to Your Honor for that.
The court will also note that the court is in receipt of an email that was sent in on Tuesday, December 2nd at 11:28 a.m., about an hour and a half after we had gone off the record on your matter. And this appears to be from your client's wife from her work email. And I wanted to go through and clarify a couple of things in the email. I don't know if you read the email, counsel, or not. But she says, just before he was released, I received a phone call from one of your officers. I want to clarify. The court does not have its own police officers. The officer that your client's wife may be referencing is from the City of Wyandotte Police Department, not from this court. So I wanted to clarify that. It's not one of this court's officers. And then I'm not sure. Your client's wife also references it was later reduced as a misdemeanor. However, should have never been that in the first place, apparently referring to a felony case. I don't know what it should have been, should have not been, what have you, when it was charged. And then also, your client's wife indicated again that she wants me to take into consideration that this was a wrongful initial charge. I don't know if it was a wrongful initial charge or not. So, because your client, based upon what was placed on the record, had a weapon, a gun in the vehicle, and it was concealed. So I don't know what your client's wife is referencing when she says not an appropriate charge or the wrong charge to begin with. So counsel, what else would you like this court to know?
Yes, Your Honor, she did show me that on her phone this morning. I noticed quite lengthy the email, and I did take a look at it, and it is consistent with what she told me. I certainly not verified any of that information, which was just presented to me this morning. I understand also that there may have been some other letters sent to the court, which I've also not seen, perhaps from employers, indicating that Mr. Juguna is a good worker. He is working a couple of jobs. He's a certified mechanic and a resident of I believe, the city of Wyandotte. He is married. His wife is present. Judge, I know that the recommendation is incarceration. Mr. Juguna, he's very remorseful for his actions. As he explained last week, this happened inadvertently. He was gathering all of his things from his workplace in Detroit and bringing them home, and the gun was in there, part of that property, and it was placed in the back seat of his car. It was in a backpack. And while it did violate the law, I don't think that it was done with any criminal intent. Your Honor, incarceration would be devastating to my client and to his family. He would lose his job and lose his house. He would lose his family. He would lose everything. I know that this is a serious offense, and the court is rightly concerned. And there is a history, and the court is aware of Mr. Juguna's history, personally, not just through the reports, but having presided over a couple of those matters in this very courtroom. We are asking the court to consider the fact that he served 4 days already, that it is not an assault offense. He knows that the weapon will be forfeited by law. He knows that there are certain mandatory and discretionary fines and costs. And we ask the court to allow him to remain out of the confines of the jail system, so that he may continue to support his family, so that he may continue to be a productive member of this community. And Judge, he is truly remorseful, and we believe that a disposition of the nature which I have indicated would probably be in the interest of justice.
So, counsel, did your client disclose to the officer that he had a gun in his vehicle?
Again, as he indicated last week, he had not even realized that he had placed the gun in the backpack. He had gathered all the property. The gun was part of that stuff that he just threw in the back of his car. He was driving home. He was pulled over, I guess, because of a tint on the windshield. So
Okay, so the answer to my question then is no. He did not disclose to the officer that he had a gun in the vehicle.
That's correct.
And what I'm hearing is that you all want this court to take into account and consideration that your client absentmindedly had this gun in his possession. He didn't intentionally have the gun in his possession. That's even more problematic, quite frankly. That tells me that your client is not even a responsible enough person to have possession of a gun. If he doesn't even know he has the gun in his backpack, if he doesn't even know he has it in his property, how is that a responsible gun owner? Which your client isn't even allowed to have possession of to begin with.
Well, he's not allowed to carry it in a motor vehicle, but I don't believe that he's disallowed from owning well, at this point, yes, but not at the time, from owning or possessing a handgun. It just was not allowed to be possessed in a motor vehicle unless, of course,
Correct.
it was locked up and safely secured in an unreachable portion of that vehicle.
Correct, which it was not.
Yes, that's correct.
Correct. And your client previously had a reckless use of a firearm charge as well in this court. And now here we are with another gun offense. I'm not discounting the reason why your client feels the need to carry a gun. What this court is tasked with is protecting the community.
And on that note, I have to say, ladies and gentlemen, whenever there's a call-in rate and I'm live, there's always the necessity to pause the video and say, "Welcome, Raiders. Thank you very much for joining us." This is the perfunctory call-in pause. Ladies and gentlemen, welcome to the show. We're finishing up a set of DiSanto clips. We're moving very quickly into anti-harassment docket Monday. Thank you for joining us. The pause is on. It's over.
Protecting the officer that approaches a vehicle at a traffic stop. Your client had an opportunity to tell the officer that there was a gun in the vehicle, in his bag. He just left work. He knew it was in the bag. He carries it on a regular basis. Illegally concealed. Right? Isn't that what you said last time?
I don't carry a gun. My wife will even tell you they was an isolated. It's, I do not carry a gun. I don't. Other than that particular day, it was early. It was early in the morning, late night, if you want to call it. Work hard. Although Saturday, I was going to go on vacation with my family. I was just thinking fast, move my tools out. I'm going on vacation for a couple of days. I do not carry a weapon. I do not carry a gun. That gun was brand new, never been shot. Brand spanking new, never get.
Well, why?
It was in all my tools. Before going on vacation, I'm just moving everything real quick because it's 2:00 in the morning. I have to come home. We have to pack. We have to leave for vacation. I was just doing stuff in the car. When the officer opens the door, my whole car is just tools and so much stuff in. And I'm not sitting here justifying this. I am not by any way, shape, or form justifying this. If it was wrong, it's a crime. And I admit that in front of this court, it's a crime. But it was isolated. It wasn't meant. I do not carry a gun. Other than this day, that gun stays in my toolbox. I don't.
Why is it in your toolbox? You use your
Because
toolbox.
of vacation. And I don't even work there every day. That toolbox doesn't, I only probably work there once a month, maybe. And I keep it in my toolbox because when I talked to my lawyer, I said, it's April and West Warren. My car got shot almost 20 times down the street on Lawton and Warren.
I understand that, but sir, you cannot have a firearm in your possession that's concealed. You do not have a CPL permit.
I learned the hard way.
CPL, concealed pistol license.
This is one of the things that I regret the most.
So having it in your toolbox is concealed.
I thought because it's private property, it could be in my toolbox in the building. I'm the only mechanic. So I was just leaving it in my toolbox for safety. I mean, I work in West Warren, a lot happens over there. But I still have to support my family. And she can tell you, I work, I'm a mobile mechanic. I literally, that's all I do is work. I support the community. I shovel snow, I fix people's cars for free. I take care of the elderly, I volunteer, I feed the hungry.
Sir, I can understand that, right? And that's much appreciated. However, you had this firearm in your vehicle, in your possession,
Yes, ma'am.
concealed,
Yes, ma'am.
in violation of the law.
Yes, ma'am.
Again,
I never had a concealed weapon before. This was,
no, before it was recklessly
Yeah, but that was-
recklessly
I'm sorry, I didn't mean to interrupt you.
recklessly discharged. That was 4 years ago.
It was never discharged. There was no.
I'm sorry, recklessly used. What?
And that was
Recklessly
the plea
used.
because I try not to go to trial with my son, who is now 21.
Yeah.
I say.
There was, then you had a disorderly conduct just last year.
Yes. And that also had to do with the police showing up. And like I said, in my wife's letter states, all this stems from me and my son. The first incident, I did not want to go to trial.
Sir,
All this
sir,
stems-
I understand all that.
Yeah,
We don't have to rehash all, we don't have to rehash all
Yeah,
that.
we have the best relationship that we've had now. And
Good, I'm glad to hear that.
yeah, we have, and you have a lot to do with that, Your Honor. The first time you sentenced me, it changed my life. I went home a different man. I looked at my son and I told him I love him, no matter what. I have been, since the last time me and you have been in this room, I have done so much to better myself and others. And I'm still looking forward. Whatever the punishment is, whatever the court does, I will accept it. It's not going to change me as a person. It's not going to change me as a God-fearing man. It's not going to change me as a man obeying the law. I will still be a stand-up individual. I will still respect you in this court, regardless of the outcome. And I thank you, Your Honor. I thank you because you did change my life the first time I came here. You made my relationship with my family stronger and better. I was on the couch of losing my whole family before I met you last time. And now things are so good. I almost lost my family. After I saw you, I had to make a lot of changes in my life. A lot. And I did. Eating habits. I don't have any friends. Everybody off. My wife will tell you. Everybody. I go home to her and my children and my dog. That's it. You changed my life the first time you sentenced me because I realized.
There's tissue right underneath there, sir.
I realized that the law is the law. You're doing your job, but the most important thing, like you said, is to protect this society, is to protect the community. And I appreciate it, and I respect that. I appreciate it, I respect that, and I respect everything you do, and everything you do for the community, I appreciate it. And that's all I have to say. And I love my family. I love what I do. I have a passion for cars. I love what I do. Every day I wake up to do this. Every day I live for working on cars and my family. That's it.
All right, here's what this court's going to do. The court finds after hearing from counsel, hearing from Mr. Juguna, reviewing the report, the recommendation, the communication from Mr. Jaguna's wife, that there's not reasonable grounds to depart on MCL 769.5. The court's going to order 90 days jail. I'm going to have you serve 14 days, credit for 4 days, suspend 72 days. I'm going to give you an opportunity to arrange with work days off. So you don't have to report until January. So you'll be serving 10 days of that 90 days jail. The rest of that is suspended, meaning that as long as you don't get into any other trouble, you won't have to serve any more jail time. No possession of firearms. And we can, I'll have you report. What I'm going to do, sir, so that it doesn't affect your work as much, I'm going to have you. My staff's probably going to kill me for this, but I'm going to have you, I'm going to have you serve those days separately. So what I mean by that is I'm going to have you report January 9th to serve 4 days. So what they used to do before COVID was work release, where you could still go to work and you just go sleep back at the jail. They don't do that anymore. Then I will have you report February 6th to serve 4 days. And then I'm going to have you serve the balance of the balance of 2 days. Report March 6th for the final 2 days. Okay?
That would be at the Wyandotte City Jail?
No. So you'll get direction from probation as to where to report, because that'd be the Wayne County Jail. So, and sir, when you report on those Fridays, you don't have to report until 6 p.m. So you can still work on that Friday. All right. And so that's day 1. Then it's Saturday, Sunday, and then you're released early Monday morning so you can still go to work. That's day 4. So I'm giving you much accommodations, not a lot, not having you to report until January, and allowing you to serve those one weekend a month, so to speak, so it doesn't affect your employment as much. and then I'm suspending the balance of the 72 days. And then I'm going to waive your fine. I'm going to indicate a $200 fine, $100 screening assessment fee, cost of prosecution $300, crime victim assessment fee of $75, justice system assessment fee of $50. That's $725. We'll apply your bond and we'll waive the rest. Okay? All right. Good luck to you, sir. Please have a seat in probation. Somebody will be with you shortly with that, okay?
Thank you for your time.
Thank you. Have a good day.
Okay, so before there's a couple of cases here that we're going to take up before we actually start the actual hearings. The first case is going to be Ms. Bradbury, Mr. Seeger Campbell. I'll come back to you folks in just a minute. But the first case we're going to take up is Mr. Cipher and Ms. Hunt. Ms. Hunt, can you come up here and take a seat, please? No. I'll tell you when the time comes. And this is down to 1. So in this case, an order was previously entered by a different judge. That order remains in place. This comes before the calendar on Ms. Hunt's request to modify the existing order. And then Mr. Cipher filed a declaration in response to your request. Did you see that?
No, I was originally going to ask for a continuance because by my servicing company, he was never served. So I'm surprised to see him here today, but happy to take care of the hearing. So I did not know that he was served.
Well, yeah, he got served. We got the packet late last week. Or no, wait a minute. Hang on just a minute.
If I may, Your Honor, I was never formally served. I received Mrs. Hunt's.
Hang on, we can hear
Oh,
from,
of course.
You're here with an attorney, so I'll
Correct. Okay.
Mr. Clark, if you want to address that, you can.
Yeah, he was not
Ma'am,
formal. Yeah, as he was saying, he was not formally served, but he did learn about this through other means. And Ms. Hunt should have received the declaration. I emailed it to her and I mailed it to her with substantial time for her to receive it.
Did you not receive that, ma'am?
I never received
Okay.
those documents.
So I think it's only just a one document. It's a declaration in response. Give me just a minute. What we're going to do, ma'am, we're going to print off a copy of that declaration. I'm going to have you review it. Then you can go back in. You can go back into the court. You can review it. And then if everybody's agreed, we'll just go forward on this motion here today. So no one has to come back.
Okay. Thank you, Your Honor.
You're welcome. Come on up, ma'am. Back into courtroom, and then we're going to do a couple of others. It shouldn't take you too long to read that. Then we'll come forward. Next will be Ms. Bradbury. Can you come back on the Zoom call, please?
Yes, Your Honor.
Hi there. So I've reviewed your petition. You have a number of doorbell camera videos that you've submitted, which I reviewed all those. A temporary order was entered. And then today's supposed to be the hearing to determine whether or not a full order will be entered. Given that he's not here, it's now coming up on 9/20, I'm prepared to enter a default order in your favor. But, I have a couple of questions first, frankly. I mean, I thought I read somewhere that, you've moved into a different apartment while this is pending, or are you back home, or what exactly?
So the complex was kind enough to move me into a new unit as this was going on, so I didn't have to be door to door with them since we're neighbors. But since this situation has happened, I am moving out, and I am moving today, actually.
Okay. And so are you moving into a different establishment, or?
It will just be a different unit, like across the way, like farthest I can get away from him.
Okay. And then how have things gone since he's been served? Have you had any issues or problems or?
Yes, the day after he was served, he tried to make contact again and enter my house.
Okay. And I thought there was the video of that, was it not? Was that?
Yes.
Okay. All right. So how far is the new apartment away from him? Because here's why I'm asking these questions, because the temporary order, I noticed, we do see no contact orders or anti-harassment orders fairly, neighborhood situations. This isn't a neighborhood, you're in the same apartment complex, but we can't really put distance restrictions on them because we can't enter an order that prevents someone from getting to and from their own home. And the distance restriction in the temporary order, which was entered by a different judge, said don't come within 1,000 feet, which isn't really practical given where he live and you live. But I will put distance based on everything you've told me. I'm going to enter, I'll enter an order that will be in place for a year. We can do a distance restriction, but I want to reduce it to an amount where he can get to and from his establishment without violating the order. See what I mean? So how far away from, it's 500 feet, 300 feet? What exactly?
It could honestly even go up to the 1,000 feet with where I'm moving. We're complete opposite ends of the complex now.
All right. Give me just a minute there, ma'am. So then an order will be entered. It will be in place for 1 year, go through December 8, 2026. And then the parameters of the order will mirror what's in the temporary order. He's not to cause you any harm, not to contact you, don't engage in stalking behavior, don't come within 1,000 feet of you, your vehicle. And I think those were the two provisions of the order. So the full order will be exactly the same as the order here.
Thank you, Your Honor.
And then since he was served and it mirrors what's on the temporary order, he won't need to be served with this. And if you want a copy, do we email a copy or do they? You can get a copy of that off the district court website, ma'am.
Thank you, Your Honor.
Good luck.
Thank you. Have a good one.
I'm going to take care of done this one. I'm going to go back to the stone cipher hunt, and then after that, I'll come to you.
Thank you, Your Honor.
So, ma'am, you can come on back up. You can take a seat. So you have asked to adjust the no contact order. In the response that was filed by the declaration from Mr. Stonecipher. Well, I guess having said that, are you prepared to proceed here today? You said earlier that you were.
Yes, Your Honor.
Okay. Basically that there's nothing in this order that prevents you from participating in any sort of investigation, which I think kind of came as news to Mr. Stonecipher, if I understand that declaration correctly. But I'll hear from you briefly as to why you think the no contact order should be adjusted.
Do I need to stand, Your Honor?
You do not.
Okay. So in seeking out legal counsel, I have been directed that I should not talk to CPS or the police or the school district about the allegations that my son has told me concerning 3 educators at the preschool that inappropriately touched him, which he is now receiving trauma therapy for. The legal counsel that I received said that that could be viewed as third-party contact and that I needed to go before the court and request that it be modified.
So I'm going to stop you for a second and tell you, I don't view that as third-party contact. Third-party contact is going to them and say, hey, go tell this person this or that. If you're reporting something, I don't think that there's anything in this order that prevents you from doing that. I know that, excuse me. I know that Mr. Stonecipher disagrees with that, but Mr. Clark, I'll come to you. What's your opinion on what I just said?
No, I agree, Your Honor. Mr. Stonecipher doesn't have any intention to stand in the way between Ms. Hunt and any kind of investigative organizations, CPS in particular. He would like this case, this motion decided on a very narrow basis. And that's in 7.105.500 paragraph 3, where in order to have a modification or termination of a protective order, the moving party needs to show a substantial change in circumstances such that the respondent will not resume, engage in, or attempt to engage in this case, acts of unlawful harassment. So none of the allegations presented in this motion would give any indication that Miss Hunt would not resume harassing my client. And for that reason, we just like this denied, and Miss Hunt can, pursue her son's interests in proper forum. Further, we'd like an order for attorney fees because they're allowed under the statute. And we're also interested in moving to seal the record because of these inflammatory statements that Ms. Hunt is making about Mr. Cipher, including asserting that she just asserted in court that he has done these things, that he and two accomplices have indeed sexually abused her child. These are horrific and inflammatory allegations, and they should not be out there in a public record. My client is a teacher and he works with young students. He hasn't had any interaction with Miss Hunt's student since June of 2023. It's not to say that, there's any time bar to the allegations that she's bringing forward, but it's just that these just seem kind of unsupported allegations and a lot of hearsay in her submissions. Thank you.
So, ma'am, I'll give you the final word here. Anything?
So, yes. So my son started sexually acting.
Okay, so, ma'am, and I don't want, the issue here is whether or not this order needs to be adjusted. And remember, he's the petitioner, you're the respondent in that order. And so with regard to, allegations that you reference in yours and was just referenced by Mr. Clark, that's going to be heard by and decided by somebody else, not me.
Okay.
And so the only issue here is whether or not this order needs to be changed.
Okay. So I've been counseled that anyone that I talk to that could then take my information and communicate it to Mr. Cipher, that could be considered third-party contact. Okay. And I'm trying to avoid being in violation of the protection order or prosecuted for participating in a full investigation, me and my son being able to be involved.
Okay. Well, I don't, as I kind of hinted earlier, I don't think there's anything in this order that prevents you from participating in any sort of investigation or anything like that. I'm not sure. Again, I'm not sure what you were told, but based on what you have said and what you have put in your paperwork that was filed, I don't see that there's any reason to adjust the no contact order at this time. It's going to remain. It's going to remain in place.
Okay.
With regard to, so your request to adjust the no contact order will be denied.
Okay.
With regard to Mr. Clark's comments about sealing the record, I don't think that. I think I'm going to need a formal motion on that with briefing, because typically we don't do that. And so if you want that, you're going to have to bring a motion on that with a brief as to how we can do that, because people file, all kinds of stuff in these sorts of hearings. And, we just don't, absent compelling circumstances, we don't seal records. And so, or court files. So you're going to have to, again, if you wish to do that, Mr. Clark, on behalf of Mr. Cipher, you'll have to, brief that. Sure. And I'm also given, I'm going to at this point, I'm going to deny the request for attorney's fees.
Under what basis, Your Honor?
What do you mean?
Did you make any findings that would support that ruling?
Which ruling?
Denying attorney fees at this time?
I think it's just, I think it's discretionary, and I'm choosing not to do it.
Okay, thank you.
Sure. You're free to go, ma'am. No contact order remained in place. And Mr. Clark and Mr. Stone Cipher, you're free to go also.
Your Honor, one more question. Does he still need to be served the paperwork? My understanding is he needs served the paperwork
What's that? No,
that I originally filed.
we've handled it here today. So this hearing is over. The no contact order remains in place.
Okay.
You may go. Ms. Is it Demeter, if I'm saying your name correctly.
Yes, good morning, Your Honor. Just, I'm so sorry. They just asked for one of my matters and just an update on it.
You can address it if you want to, and we can come back to you. I got plenty to do.
Okay, yes, thank you. Thank you, Your Honor.
Sure. Okay, so we're going to start. Next case we're going to take up is Kashayla Panavarov and the Boutons. Ms. Panavarov, you can come up to this table, and then the Boutons can come up there. Mr. Pruitt and Ms. Jordan, you can come on the Zoom call.
I don't mind going last, Your Honor. If you,
What's that?
I don't mind going last if you have other cases.
Now, there's only one more. You can take this one, then we're going to do the last one. So we're getting near the end. But I do need you on camera, ma'am.
Yes, I'm working on it. Let's see. Is it on? Okay, I think it is.
This is on. So for the record, as soon as my computer catches up to me, this case was filed on November 14th. A temporary was entered, and then back on November 10th, it appeared it was reissued, then it was served. On November 24th, a default was entered because Ms. Jordan didn't appear. And then on the 25th, she filed a motion to basically set aside the order. So it's on for today to determine whether or not the order should be set aside, or we should have a full hearing on whether the order should be entered at all. And so one thing that she did mention there, Mr. Jordan, or Mr. Pruitt, sorry. Mm-hmm. Apparently you filed an order against her last July, is that correct?
Yes, Your Honor. Mm-hmm.
And that was not granted, is that also correct?
Just got the temporary one due to the injuries I had, Your Honor, but yeah, it was upsetting because the first judge, I guess, first instance, they just thought, oh, you guys should get along, and then it was dismissed.
Right. So what's been happening since then?
Oh, Your Honor, she came knocking on my door.
Hang on just a minute.
Oh.
And so, ma'am, I'm going to swear him in. I'll hear from him. Following that, I'll hear from you, and then I'll make a decision about the order. All right. So raise your right hand there, Mr. Pruitt, or Dr. Pruitt, I'm sorry. And then Ms. Jordan, just one at a time. I'll get you in a minute. You can put your hand down. Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
Go ahead. I'll hear from you.
Yes, Your Honor. So, do you want me to go into why I got the original order, or
no? I want you to tell me what's happened since the original. Because she's saying, well, you know, a judge looked at this, decided an order wasn't necessary, and now here we are again asking for the same thing. So it's kind of your responsibility to tell me, okay, all this stuff has happened since that, which requires an order, and that was so. That's
Roger that, Your Honor.
That's what I want to hear.
Okay, so the first thing that triggered me wanting to get a second order was that she came knocking on my door. It was after midnight in October, and I knew it was her because I happened to be standing by the door. I don't think she knew that. So she used to do that when I got my first order. She would come knocking at all hours and ringing my doorbell. So she was starting her antics again. And then so she got arrested the first time for violating the order, and she's been doing like retribution ever since. So she's been filing orders against me every couple weeks. She's got a pattern of doing this, Your Honor. It's very much harassment. I mean, I've been to court every like couple weeks now because she's trying to get something against me because of the original order she got arrested. So I keep getting emails from her. She's sending them from the library after she'd been served. So she's violated the orders 3 times now, and she's been arrested once. So I talked to the police and filed reports both times, and they've sent it off to the district attorney's office, is what they told me, for them to put something against her. But it's her continuous pattern. I mean, she has dozens of items under her name, Your Honor, that she does this to people using the courts when she doesn't get her way or she's upset with somebody. So it's a combination of her doing her childish antics again, knocking on my back door at all hours of the night. She's sending me emails when she's not supposed to because I've had these orders in place. And then it's her.
What does she say in the emails?
It's just the paperwork for her new orders, like she's harassing me any way she can. She's just sending me emails of the paperwork she keeps filing, but she's not supposed to contact me. She's supposed to serve me like normal. So she's violating it by contacting me that way.
So now provide me some background on how are you two acquainted with each other?
Yes, sir. And she's always denies this, but I was living in Lacey, and I met her on a dating site, and we got to talking, and I was looking for a place to live. And she said that there were some townhouses by where she lived that were open. So I came out and got the number and stuff, and I got the apartment. So I moved in. We dated for a couple weeks, but she really got some mental instability going on, Your Honor. And so I told her I didn't want to date her.
Ma'am, I need you on camera. I need you to stay on camera, please. Thank you.
And
so do you guys still live near each other?
Yes, Your Honor. We live about a football field away from each other. Her front door faces my back door, but there's an intersection in between us, so it's not like we're near each other. She says all kinds of stuff, from I go to her place, I park by her, I harass her, but I haven't had contact with her in months, ever since the first order that I put against her. I haven't talked to her, emailed her, nothing. But she keeps harassing me with these orders. She's got no basis for anything.
Okay. So, ma'am, let me hear from you. Could you raise your right hand, please? You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
So I'll hear from you on how many times have you guys poured over orders?
Twice. Your Honor, there's a pending, I'm looking at this case right now. It's a little confusing, but his exact testimony to you today is the exact testimony he gave the previous judge back in
July,
case number 25-000227, I believe.
Yeah.
That case.
And he's saying that it's ongoing. He's saying things have happened since then.
Well, that's correct. He has been initiating contact with me, which is why I had to file an order in Superior Court, which is still pending, Your Honor. We have an upcoming.
What's the cause number on that?
That one is the one, I filed it a week and a half ago with an attachment.
What's the cause number?
Case number, can I reach for it really quick?
Yes.
That is the 25-2, wait, this is not it. Your Honor, it's case number 25-2-30666-34. We have a hearing there in 2 weeks. There's a stay in that case pending transcripts. Continued harassment, new evidence of harassment.
Okay.
Aside from the transcript, Your Honor.
So if what I'm hearing right, he's saying, she's harassing me, and then you're saying he's harassing you. Is that
right?
Is that what you're saying, Tim?
The only difference is I have evidence and he does not.
Okay.
But he thought that the case was over in Superior Court, so he decided he was just going to file another case in District Court because he was mad about the judge ordering him to surrender his weapons, is why I think he just randomly filed a case and the case that he just filed, the 00345, is identical to the one that was denied in July. Okay. So I was very shocked to get this, Your Honor. And the only way I knew about the court date was an officer brought me the paperwork. I think it was 2 weeks before the hearing, but I couldn't make the hearing because I had a medical issue that Friday. But I wish I would have handled it sooner. I just physically could not. But yes.
Well, ma'am, this might be one of those instances where, again, I don't know. The only thing in front of me here right now is to whether to set aside that order that was entered here a couple of weeks ago. And it looks to me like you've been a petitioner on 15 different anti-harassment petitions. Is my count wrong there? And then how many of those involve Mr. Pruitt?
There's 2 with Mr. Pruitt, and there's 2 or 3 others. I don't know where he gets the number. Apparently, he's been.
Well, where I get the number is I'm counting them. They're right in front of me, and I see that there's again 15 different petitions, both in district and superior court.
The court's familiar with the Johnson case, which is still in appeals right now.
All right. So here's what I'm going to do for today. And like I say, maybe that superior court can just proceed. And again, maybe it is an instance where, again, I don't know anything about how you perceive Mr. Pruitt to be harassing you, but the order in this place is, hang on, just let me finish, ma'am. Ma'am. That's not in front of me. That's in superior court. But yes, the order in this case is going to remain in place, be in place for a year. And again, I think it'd be a great idea for you just not to contact each other.
Can you modify that to 150 feet then? Because he's within 125 feet of me. He just moved. And yeah.
I wonder if I could respond to some of that.
I thought that supposedly he got evicted.
Okay, just hang on for a second there, Ms. Jordan. The only thing I want to hear you respond to is the distance restriction, Mr. Pruitt.
Yeah, roger that, sir. We live a football field away from each other, and I don't go over there. So.
Okay, give me just a minute. Let me look at the.
Yeah.
I've been at my place for 6 years, and he's trying to restrict me from being in my own area.
That's not going to happen, ma'am. That's not going to happen.
He's a block, not even a block away, and faces my door. But like I said, this was already heard and being heard in the Superior Court right now.
Well, so your petition against him is being heard in Superior Court. His petition against you is being heard here right now.
Yes.
And Your Honor, we've been to court like 6 or 7 times because she does the continuances and then she needs extensions and then she waits for this and that. So
just a matter whether or not the distance restriction is appropriate.
3 hearings, Your Honor.
Yeah. Actually, no, I have to.
Okay. So I'm going to reduce the distance restriction there. You're not any email correspondence that doesn't involve you. She can email you legal documents, but anything that doesn't involve legal documents, you're not to email him. And then the issue of coming to the door, you're not to come within 100 feet of his place. And the copies of this will get to you. And again,
Your Honor, is there
and
anything?
then that'll be that. Yes, sir.
Just wonder if there's anything we could do about
Thank
the
you.
excessiveness of this. She obviously uses the courts as like a weapon, and can we restrict her from doing this in the future?
Well, I think you probably heard me say to others, I can't.
But this has a pattern, Your Honor.
Generally, I can't at this point. She's not the petitioner here. So sometimes if people go as a petitioner at the same court, there are things I can do, but she's the respondent now. And if you can bring this up, if the petition she has in Superior Court, I think the other one was here, you can bring that up with the Superior Court judge, see if you can restrict that. But with regard to this.
Okay.
Again,
yes, Your Honor.
Again, I'm not going to restrict what she has a right to do.
I know, just
Can
because of the
can I
pattern.
note
The
the
pattern, Your Honor.
fee, Your Honor?
Can you do what?
Could I note down the feet?
Yeah, 100 feet. But ma'am,
And I don't harass her, Your Honor. I have not made contact in months. I don't even look in her direction because she.
Okay,
doesn't.
so hang on.
That's
hang
not
on,
true.
Just stop. Everybody stop. Everybody stop. Okay, I've made my decision. Nobody needs to say anything. Okay, and I'm going to say, ma'am, again, I won't say anything either. You're just not to contact him, and don't come with him within 100 feet of him, workplace or place of employment.
He doesn't have a
And
job,
copies
Your
of this will
Honor.
get emailed to you.
I'll come pick it up.
That's okay too.
Thank you.
And you both are free to leave the Zoom call.
Thank you, Your Honor.
Ms. Castillo and Ms. Alejandro can come on the Zoom call, please.
Yes,
Excuse me. Give me a second to get your case called up. So Ms. Castillo, could you raise your right hand, please? You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth.
I do, Your Honor.
And then how is it you need an order against Ms. Alejandro?
I just need any sort of harassment behavior to stop. Any coming to my front door, coming to my back door, watching me walk to my apartment from her side of the building, hitting the window. I know you can't stop her from reporting to my apartment, but on my personal behalf, I would prefer if you wouldn't false report me of smoking to my apartment and creating more issues for me. I don't also want to be contacted from any no caller ID, no second fake phone number. I don't want to be contacted from her phone number is blocked, but if there's a way around that, I do not want to be contacted in any way.
Well, what sort of conduct has she been doing that leads you to have this case, file this petition?
Yeah, absolutely. So, I would just say the constant coming to my front door prior to being served, also constantly blowing up my phone, whether it is calling me multiple times during the day while I'm at work, also texting me multiple times a day. I mean, tens of like multiple times a day. And then if I don't respond in time, coming to my front door, and if I don't respond to my front door, going to my back door and yelling my name through my windows.
Have you told her to stop?
Absolutely, yes, I have. I have clearly
And
stated
what
my
sort of things is she texting to you, again, specifically?
Yeah, as I've sent in, there's things like, I have found you, I hate you, you ruined my life. I also have these text messages of, after I've stated my boundaries of not blowing up my phone and I'm not available to her emotional distress. She stated that taken a bunch of pills, ready to sleep. So, threatening self-harm behavior, which worries me. I do care about you, and I don't want to get threatening phone or text messages as prior. Also, just I have also these messages. Sorry, Your Honor, I should have had this pulled up. But really just anything I've gotten many messages of just really anything, of coming up with any sort of excuse to have some sort of conversation. Are you home? Did I do something wrong? Are you up? I wish you were up. I'm emotional. She tells
Hang on.
me,
Did you guys used to be friends?
yeah, we are neighbors, but we used to be kind of friends for, I believe, like a month or two. I was unemployed and she is unemployed at the moment. So we would, go hang out, go to the lake or do something. And then the behavior just started to become excessive to the point, the biggest point I forgot to mention, which I also have the witness statement for, of when I was home, and I don't think she knew that I was as close to the door as I was because it was quiet in my home. But one of the many times she came to my front door, one of the last times that made me file this protection order is when she tried to open my front door. We heard her tamper with the door handle, and I wasn't sure if she was trying to pick it or not, but that was one of a very scary moment for my partner and I. Sorry, Your Honor, I'm a little shaken up, but yes, we used to be friends.
Let me hear from her. Well, actually, one last question for you. How far away does she live from you?
Yeah.
How far away from you does she live? I think I should have said that better. Go ahead.
Yeah, no worries. I don't know the exact feet. I know for sure it's about 10 feet away, but apartment building M is split into two separate buildings, and she's on the right building and I'm in the left building. So there's definitely enough room for 10 feet.
Let me hear from here. Ms. Alejandro, yeah, I'm
Yes,
assuming
Your
you've
Honor.
read the petition, you've heard her testimony. Could you raise your right hand, please? Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You can put your hand down. What's your response to what you just heard from Ms. Castillo?
So I haven't even had contact with her for the past month. And also, as much as I have a problem of self-harm, I do have a history. I will admit that. I have therapy right now. My therapist told me, instead of talking out my feelings at the moment, since I'm not always able to go on walks. And since I just moved here, I only walk within the apartment building because I don't want anything to happen to me. I am just a girl. And I am about to move due to the appointment, and I won't even be here for a whole year. Sorry. And she has a history of self-harm as well, where she has called me crying, texted me crying, and saying that she has taken her meds and then drank with her meds or smoked with her meds. And that's worrying because I don't want anything to happen to her because, like she said, we used to be friends. And me personally, with family members who have passed away, I didn't want anything to happen to her. I'm sorry.
It's all right.
I just care very strongly about people who have self-harm or any type of thoughts. And yes, I do admit I did blow up her phone. Certain days I just wanted to vent, or certain days I just really wanted to know she was okay because I didn't hear from her. And knowing our problems, I wanted to make sure she was okay.
All right. Well, you understand, based on her testimony, you know, the amount of conduct is kind of concerning for her. And again, she's saying that you tried to get in there one time, and that was kind of concerning for her. Do you understand that also?
Yes, Your Honor.
And then go ahead, sorry.
When we used to be friends, half the time we'd have the doors unlocked and we just walk in through one of each other's house. So me personally, I was just used to that factor, and I think that's why I attempted to open the door. Just, sorry, I'm at loss for words.
Well, go ahead. You can continue.
I think it was just the fact that it was an involuntary, like, mental response. Like, I was so used to it. I think that's why I did it, because I wouldn't have done that to hurt her. I only had care in my mind for her.
All right. So, ma'am, based on Ms. Castillo, I'll give you the final word. Anything you want to say in response to what you've heard?
Yeah, I guess I would just personally like to tell Jordan that I 100% care about you, and I'm trying to understand your perspective, although you've sent me into several panic attacks. I am in therapy just regarding our relationship and how you've pushed boundaries. I constantly have to take my panic attack medications because I am frightened that somebody's going to come to my door or watch me go to my door. I don't like being watched. I've already told you I am diagnosed with PTSD, and I would have loved to continue being friends, but the excessiveness has damaged my emotional state and my mental health, and it has hindered my day-to-day life because of how frequent you came to my door without permission. But thank you for explaining yourself. That's all I have to say, Your Honor.
And do you still want the order?
Yes, sir.
So, Ms. Alejandro, Ms. Castillo, based on the testimony combined with your petition, I will find that is a pattern. And I understand you may have good intentions, Ms. Alejandro, but based on the evidence presented, I am going to find that the pattern is such that an order is appropriate. So I'm going to enter an order. And I guess it's my hope there, Ms. Alejandro, that you don't contact Ms. Castillo, but this would give you an opportunity to where you can concentrate on yourself, and don't let Ms. Castillo work on herself. You can work on yourself, and then you can not be distracted by each other, and then hopefully both of you can get better, which would be my hope. But the order will be entered. It'll be in place for a year, and if you move, it sounds like, are you in the military? Do you have a spouse that's in the military?
My husband is in the military, Your Honor, and I am moving in 5 days.
Okay. All right. Well, good luck to you. And a copy of this will get emailed to you, and then that'll be it.
All right. Thank you, Your Honor. Have a wonderful day.
Thank you.
All right. Our next matter, Mr. Commandant, if you would join us.
Good afternoon.
Good afternoon. This is Golden Pond Estates versus Millerans, Travis Millerans. Also occupying the premises is Randy Bailey. Ms. Bailey, is Mr. Millerans with you?
Yes, Your Honor, he's right here.
Yes, sir. All right. Hello, Mr. Millerance.
How's it going?
That's going all right for a cold Monday afternoon.
Yeah.
Mr. Steve Cromendike is here for the plaintiffs. This is a termination of tenancy matter, just cause, 3 lates in 12 months, and I think other just cause. They want you to move your mobile home off of this lot, number 3. You don't like that idea much, and expressed that last week. You have filed a written demand for a jury trial, and we received that on December 5th, and I believe you also paid the $50 jury demand fee. Mr. Cromendike, what's your position?
Just to be clear, this is not, this just has to do with health and safety concerns, not with
Yes, not 3
payments
lates.
over a 12 months.
Yes.
Yep.
I'm sorry, we said that last week.
Yeah, so and where we had left it last week, I think my assistant submitted some of the documentation I have. There have been some incidents with Mr. Elliott, who is on the Zoom call here, who is does maintenance for the park. And so he's attending, and if you'd like to hear from him, we had left it last week that I had made a FOIA request and was waiting on police reports, as the police have been there a few times, but still do not have them. I think you had said you were going to call and see if you could get a copy of them as well. When we reached out to your office earlier this morning, it sounds like you hadn't or didn't have those yet. So I don't have any police report.
I got our file numbers. And at least I only know the things that resulted in a charge.
Okay.
So if there was a charge, we'd have a file number. If there was a complaint made, I don't have that. At any rate, the defendant has filed a jury demand, and so we're going to need to set this for a hearing. Also, I got I didn't know what it was. During the lunch hour, I got an email. And I opened it before I really knew what it was. And it was apparently Mr. Millerance bitching out Golden Pond Estates, cursing at him.
Yeah, that was my assistant sent that over just as that's the documentation, shall I say, that we have. So I wanted to make sure that you had it.
All right, we're going to need to set this for a hearing. Mr. Millerance, can you hear me?
I can.
All right, you've demanded a jury trial. I started here 23 years ago. We've yet to have a landlord-tenant jury trial. Judge McManus was here for 36 years before that. I think maybe he had 1. You don't know the rules of evidence. You don't know the rules of procedure. You don't know how to introduce evidence. And you want to have a jury trial where you're going to bring in 36 of your fellow citizens, try to represent yourself in this case, selecting a jury, making an opening statement, presenting evidence, cross-examining witnesses. It isn't as easy as it looks on television. Now, you had indicated that you were going to have Meg Bauer represent you. I have not seen anything from legal aid, and Ms. Bauer's been gone on a trip. What's your position?
She told me after today's court hearing, I have the email to contact the office and set an appointment with her, so they can further decide if they're going to fully take on this. She advised me to file this, and I did. My position on it is, you're very correct. I will have everybody in this park against them. Currently, there's sewer backing up in people's homes.
And don't even want to pay the bill.
And this happened as of last night. And has been like this for a week.
Oh, and say that again. Your sewer backed up?
Yeah, it's in more than one person's trailer, and Jared is complaining about it, but this
Well,
is
did
an
it back up
ongoing.
into your trailer?
Yeah,
Okay.
but this is a problem from lot 1 to lot 7. There's tree roots in our ground, and if they would do the proper investigation from what everybody knows out here for 11 years, then they would know that this is an ongoing problem, and they're gonna have to deal with it, whether they like it or
I
not.
will, those may be two separate things. Now, if you are threatening to beat up the personnel at the place or doing
No,
other things, to call
that never
the
happened,
police
Your
to
Honor.
come. Stop. What I heard, and I didn't really know what it was till I opened it, is you calling them up, being very rude and disrespectful and swearing at them and telling them you're not going nowhere. This is your home. Once
It is my
McBauer
home.
hears that, you probably won't want to touch this with a 10-foot pole.
She knows what has been said. I've told her.
And I'm not trying to be rude, but this Dave guy, ever since he took over this park, he's treated nothing but all of these tenants in this park like trash.
Like word lower than a
Well, let me
blow.
ask you this. If it's that terrible there, why
No.
don't you want to move?
Because he's barely ever out here.
Because I've lived here for 11 years and this is my home.
Well, you own the trailer. You don't own the lot that you're on.
Travis said he's more than happy to sign like a conditional dismissal to where he has an agreement with the whole park and with Dave and Jared and everything to where he won't get in trouble, where he won't say nothing to nobody or anything. Like I stated last week, though, he also is getting ready to take anger management. He does have mental health problems. His medication interacts with each other, and he has an appointment December 15th regarding his medication. And I do have witnesses to the fact that Dave came running all the way from the end of the trailer park to get in Travis's face when it had nothing to do with me and Travis.
All right. Now you are listed as all other occupants. There is no lease here, Mr.
Right, because when I
Cromendike.
go into the email, it won't let me sign it. It never would.
Slow down. Mr. Cromendike, was there a lease at one time?
I believe so. I can go online and check right now if there is one.
No, there's not. But if you go into the app, it says my lease is good until 2026. But I haven't signed a lease because every time I open it, it takes me right back to the app and it don't give me an option to sign anything. And I've been trying to figure that out since August.
Bailey, slow down. Was there a lease at one time?
No, I haven't had a lease since they took over the park.
Yeah, I do not see a
When was that?
lease in here. I'm not sure when they took over this park. Dave or Casey, can you guys speak to that?
It's been probably close to a year. It's probably right at about the year mark.
It's about a year and 2 months, 3 months.
So you don't even have a lease. You're
Which
living
isn't
there.
my fault.
Well, it isn't a matter whose fault it is. You don't have one. A
There's a
lease
lot of
gives
people
the
who don't.
tenant certain protections, and whatever previous lease you had is lapsed. So you're living there without the benefit of a lease, which means you're what's called a tenant at sufferance. And they want you to move and remove your trailer. So you don't have the protections that you would have in a lease, because whether you didn't sign it or they didn't sign it, there is no lease. So you don't have the protections that a lease provides. You got a tiger by the tail. You filed a jury demand, apparently on the advice of Meg Bauer. And so I don't have any discretion to circumvent that. We need to set it for a jury trial.
I mean, Travis is more than happy to start doing stuff. Jared and Travis had spoke before Dave and Travis got into this argument that had nothing to do with me and Travis. Jared had told Travis last year when there was a problem with Dave.
Well, who is Jared?
Oh, he's the owner that nobody even knows.
Jared is one of the owners, Your Honor. He's a member of the entity that owns it. Jared also owns the property management company, which handles management of the park. So when he's talking with Randy and Travis, my suspicion is that it's in his capacity as the owner of the property management company.
Yeah, Travis and Jared had an agreement that if there was a problem out here, Jared would speak with us instead of Dave. Then it went from nobody communicates with anybody.
No, because, oh, that's right, because they don't have time for this trailer park.
We don't even have a manager out here to report anything to. I have text messages from Jared telling me it's not his problem to worry about things out here. Let the police handle it. Okay, the police stood on my porch and told me multiple times to get Jared on the phone or a manager because they wanted to speak to him. They refused.
All right, well, this is filed as a termination of tenancy. They allege numerous violations of the park regulations and procedures. You don't have a lease, so you don't have the protections.
I don't
of
even
the
know
lease.
what the rules of the park are.
Good point.
And I've never had a
Anyway.
violation.
Well, they're alleging that Mr. Millerans has. And
Well,
these
I mean,
foolish
where are those
voicemail
papers?
messages you just left
Well,
do not help the situation at all.
where's this written proof at?
Because we've really never been wrote up for anything.
Well, I guess we'll find out.
And how am I such a bad person out here when all I do is
Well,
try to
I'm
help
not,
people out?
I don't have an answer to that because I haven't heard the evidence yet. But they want it sooner than later. I'm going to set it for jury trial for January 28th, 2026 at
Like this
8:30.
is ridiculous.
Well, maybe so, but I didn't
Yeah.
bring this case. They did. They want you to move. And so they brought this lawsuit to get me to compel you to move. You've demanded a trial in front of a jury. And you have a right to do that. You've paid the $50 jury demand fee. You don't know what you're doing. You don't have a clue one as to how
It
to
doesn't
pick a
matter if
jury
I
or
know what
how
I'm
to.
doing, Your Honor.
I
But if Mike
filed it.
Bauer,
My
what?
wife is going through school for everything.
I'm in law
what you're talking about right now.
Literally.
We know what we're doing.
I know how to pull
You're
the
in law
MPL
school,
codes and all
Ms.
that.
Bailey?
Yes, I am.
Law school, yes, she is.
At where?
Southern New Hampshire University. Have been for 2 years.
Southern New Hampshire University is an online university. I don't think they have a
Yes, they do.
Boston accredited law school, but you're
They do.
apparently. Well, all right.
We don't know what we're doing.
All right, so
But no, I mean, we're more than willing to sign paperwork, stay in. Travis won't say anything to nobody or get in trouble or do anything like that, which is a conditional dismissal. Obviously he's gonna take anger management that I have to pay for $250.
How would we
Part of his
define what
probation.
getting in trouble is in a conditional dismissal?
I mean, I've had one before, so I'm sure Judge Middleton could explain that to you.
well, he knows what it is. He's just wondering whether you understood what it is.
Oh, no, I understand because in fact, when I had 3 other owners prior, they did do one with Travis because of my neighbor. That still is a problem.
I've even asked Jared when he took over this park.
All right, just stop.
Why
I'm
can't
gonna
I
set a
talk?
jury trial. Because I didn't ask anything. You don't just blurt stuff out when you're in a courtroom. I'm trying to schedule this matter for your requested jury trial. We're not taking any testimony at this point. Nobody's under oath. Now you guys can discuss it among yourselves and see if you can come to a conditional order of dismissal. But they filed to terminate your tenancy for multiple violations. You filed a demand for a jury trial. So I'm going to set the jury trial for January 28th at 8:30.
And will I be there in person?
Yes, your
Oh,
witness and exhibit lists are due by January 9th.
Okay.
I won't be there.
Why not? You don't want to be there on January 9th?
28th.
28, no. We're gonna have witness and exhibit list due by January 9th. We're gonna set a pretrial conference in advance of jury.
And we got a lot of people out here backing us up.
And you need to subpoena all of them.
All right, we'll get right on there.
And now, in the meantime, you can discuss some sort of potential conditional order of dismissal. There are lots of issues at this park. It's a transition from an old privately owned to a new partnership owned property. There's well issues, there's septic issues, which predate everybody here.
Right, pond water.
This juncture, though, they simply want you to move. You are adamant that you don't wish to move. You don't have a lease. You don't own the lot. There are habitability issues with the lot if the sewage is running back into your trailer. But I'm gonna try to force this to a head. Now, all your witness and exhibit lists are due by January 9th. I'm gonna set a pretrial on that day. That's an ugly day. Oh, gee whiz. Already got a trial set that day. I wish they'd put the name in there. I've got a termination of tenancy case set for that afternoon. Oh, it's Williams. Ugh. I'm going to set it for Friday, January 9th at 11 o'clock. (11 to 12) pretrial. So you have to file your witness and exhibit list by that date. I would ask you to file your jury instructions, but I don't want to put Mr. Cromendike to that until we actually decide whether we're going to have a jury trial on the 28th. But you have to submit your witness and exhibit list. If you got 27 witnesses you wish to call, you have to provide for them to be there. You have to subpoena them or get them to agree to come voluntarily. We'll block out one day for this jury trial. I'm not gonna spend a 5-day chasing my tail over this. So in the meantime, you can discuss a potential conditional order of dismissal. Mr. Cromendike, I'm willing to put everybody, you and Ms. Villa and the defendants, in a breakout room right now to discuss some of those things. I think Mr. Elliott might just add fuel to the fire, but I'm at least willing to put the three of you in there. What's your perspective on that?
I'm not against it at all.
All right.
Mr. Elliott, you're
good. What?
Before you do you know when Meg is going to be back from her vacation?
No, I don't. She was gone and then she was gone again. I haven't heard whether she's going to file an appearance in this matter. according to Miss Bailey, she's the one that told him to file the jury demand.
Yeah,
Yeah.
I can send that to Mr. Cromendike. I mean, I have no problem even showing him what Meg told me.
All right, you
She told
guys
me
can
if the
discuss some of
hearing
that.
was adjourned today, she told me to call the office after the hearing today and schedule a phone appointment with her. But they couldn't do nothing because she was going to be gone, so she couldn't like accept the case because she was going to be gone. But now after this hearing today, I'll have to hang up and call them and schedule an appointment
Well,
with
if
her.
legal aid gets in, it will be in a better posture.
And
But for now,
I did
they're
talk
not.
to Meg about this beforehand as well. So I have talked to her about it already.
All right. Does it sound like she was going to get in it?
She wasn't sure at the time.
All right. The email that you forwarded to us,
Yeah.
I would suggest perhaps you share that with Ms. Bauer also.
Yeah.
All right, I'm going to put you guys all in a breakout room. At least you can talk for a while. Mr. Elliott, you're good to go.
All right, thank you, sir.
All right, thank you.
All right. 14A District Court for County of Washington, State of Michigan is now in session. All those have business before the court draw near. The Honorable Judge J. Cedric Simpson presiding. You may be seated.
Okay, and who's swearing this out for me? Ooh, me?
Yeah.
Ooh, I look pretty. Oh, that's fine.
Okay.
Yeah. Is it? Yes.
It is, yes, I'm sorry.
Good afternoon. You could raise your right hand. Do you solemnly swear or affirm the information testimony you're about to give this court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, state your name, your department, and please tell me what you know about this.
Detective Jessica Quinn from the city of Ann Arbor. On 10/15/2023, at approximately 02:12 hours, officer responded to North University and South State Street on a shooting. Radio information was that there was 5 to 6 shots fired. And this information said that over the radio that the shooting had just occurred. Upon arrival, Officer Sparling met with witnesses that said someone was trying to steal something. Officer Downer also located video recording of a white pickup truck that fled the scene at a high rate of speed. On the video, she could see that the plate was Edward William 1356, and that came back to 2016 Dodge Ram 1500. The registered owner of that was Timothy LaShawn Lacey, who resides at 10675 Bryan Circle in Willis, Michigan. Officers did locate Mr. Campbell, who is just one second, sorry. Jane Campbell?
Yes.
He advised that they made contact with Campbell, and it was determined that he was involved in the shooting, that he had fired shots in the shooting, and that he was in possession of firearm, and he was placed under arrest. Also, a BOL was put out to other officers in the area concerning that vehicle that had fled the scene, the white pickup truck. Deputy Early and Deputy Heath from Washoe Sheriff's Department located the suspect vehicle traveling eastbound on I-94 east of Willow Run, bypassed west of Rawsonville Road. Those deputies located Timothy Lacey driving and Tamarian Jones in the front passenger seat. They placed them under arrest and they located a firearm under the front passenger seat where Jones was seated. Officer Polger and Officer Rourke met them at the scene. In the front passenger seat, they also located a receipt for the Bodega Brothers, which is a business that Shane Campbell was at, and all subjects at that involved in the incident were also at. Jones was wearing a black hoodie at the time of his arrest with a black ski mask on his head, which was described by Campbell. And Lacey was wearing a white t-shirt. I was called in as the on-call detective at 3 o'clock in the morning and was advised that we had a shooting and that subjects were in custody and to come in to interview the subjects. When I interviewed Campbell, he said that he went to a food place, which was later determined was Bodega Brothers, and he noticed one guy with a ski mask on and one without inside of the restaurant. They began laughing at him and his friends when they walked in. His friends, one of his friends was named Elena Bender, and there was also a gentleman named Barry and Jay, he described. He and Elena had gone outside because she was arguing with her ex-girlfriend on the phone. Campbell went outside to get her. Elena was sitting beside the, like a planter that holds trees. Ken and Elena were walking back when they approached by two light-skinned black males wearing ski masks. One was wearing a white shirt and the other was wearing a black shirt. The one wearing a white shirt said, "Yo, I'm gonna need your gun." The one wearing a black shirt drew his gun, so Campbell drew his gun. Then the one in the black shirt shot his gun and Campbell shot his gun. Campbell said he shot after he shot at me first. Campbell said he did not recognize either subjects from previous to that night, but they were the two that were inside the restaurant that had laughed at him and his friends. Campbell said that the male in the black shirt must have had a bullet already chambered because he shot at Campbell, and Campbell had to chamber a round before shooting. I then called Elena Bender on the 15th on the telephone, and she advised me that she described the incident saying that they were approached by two males with ski masks on and they were trying to steal Campbell's gun. She thinks they shot first. She said that they were trying, she said that when the shooting happened, she ran, and afterwards Campbell ran to get his car, and then they all went back to Bodega Brothers. We then obtained video from 830 North University School, the School of Kinesiology building from the University of Michigan Police Department. 39 minutes into the video, we observed what appeared to be Timothy Lacey by the vehicle that they exited out of, which was a white pickup truck, and the clothing description and the statute of the males. Timothy Lacey exited out of the driver's seat, and Tamara Jones exited out of the passenger seat of the white pickup parked in front of the bodega building. Lacey appeared to be ducking behind a vehicle, and Jones also appeared to be ducking behind the vehicle, behind the cement planters boxes on the sidewalk in an attempt to sneak up behind somebody. The best way to describe it, it looked like they were almost hunting something when they were ducking behind these planters. Both Lacey and Jones darted out of view of the camera and then returned back into the view of the camera running. That would be around the time that the shooting occurred. They got inside the white pickup and fled the scene westbound. And today we are seeking to amend the charges of robbery unarmed for Lacey, weapons carrying concealed, and robbery armed.
I should have said, because this is People's State of Michigan versus Timothy LaShawn Lacey.
Yes.
And based upon that testimony, the court does find that there's probable cause to believe that the individual alleged in the complaint has committed the offenses, but also particularly the offense of armed robbery based upon that information. And the court would authorize that charge.
Thank you, Your Honor.
Thank you. We're ready on his, or?
We are ready on Mr. Lacey's case, represented by Mr. Ellman, I believe.
All right.
Still waiting on Mr. Perkins. I don't mind calling them one after the other if the court
Is your client waiving?
I believe so, yes, Your Honor. We have a signed waiver.
Okay. Well, why don't we get him out of the way then if we can?
Your Honor, we need to arraign him on the new.
Yes, we'll arraign him on count 3. And then,
And this was something Mr. Ellman and I had discussed prior to today. This wasn't a surprise, Your Honor.
That's correct.
or does call the case of the People's State of Michigan versus Timothy Lacey.
Good afternoon, Your Honor. Ashley Lundy Feltus for the people.
Good afternoon, Your Honor. Robert Ellman with and on behalf of Mr. Lacey. Mr. Lacey, can you please state your name for the record?
Good afternoon, Your Honor. Timothy Lacey.
The first thing that we would need to do, this is date and time set for preliminary examination. First thing we'd have to do is, Mr. Lacey, there has been sworn out and added a count 3 of armed robbery. And the court would advise you that that is a felony punishable by life or any term of years. You understand that, sir?
Sir.
All right. Mr. Ellman asked me, Raymond, on that.
Your Honor, we would waive any further reading and stand mute.
Defendant having waived formal reading, standing mute to that charge, court will enter a not guilty plea on his behalf at this judge.
Thank you, Your Honor. That was something that Mr. Ellman and I had discussed, so he did have notice that that was coming today. It wasn't added without him having that information. So I just wanted the record to be clear on that. And Your Honor, there has been an offer extended to the defendant upon a waiver of preliminary examination on all 3 counts. The people would allow the defendant at the first pretrial to plead to counts 1 and 2, unarmed robbery and carrying a concealed weapon with the benefit of hideout. But there are no other agreements as to sentence. And I believe that the guidelines I've calculated on the unarmed are in at least the 50-month range. I think it's 54 months at the bottom. So there's no agreements as to sentence. But if he should waive today, that offer will be available to him at the first pretrial. Mr. Ellman and I have also discussed the possibility that pretrial may need to be adjourned so he can have sufficient time to think about it. But we're not in the business of allowing it to.
Excuse me, one moment. You're going to have to back up 1 row, folks. Just back up 1 row.
Yes,
Thank you.
that is the sum and substance of our agreement.
And Your Honor, we've discussed that, and based on that offer, we are going to be waiving today. I have an executed waiver form if I could approach. Thank you, Mr. Allen.
I should also say for the record that at this time, the people are going to be filing a penalty in the case of Mr. Shane Douglas Campbell. At this time, the people do believe that Mr. Campbell was a victim in this case, and we do intend to treat him as a victim. If that is reduced to and formalized into a cooperation agreement, we will provide that to defense counsel. I do have an immunity agreement. I'd like to report an order for immunity for Mr. Campbell. Should he have testified today, does contemplate testifying at trial as well, that I'd like the court to consider and sign with the idea knowing that Mr. Campbell, in this instance, was also charged originally with carrying a concealed weapon and possession of a firearm by a prohibited person. The people do intend to dismiss that case today against Mr. Campbell.
And
Defense counsel has gotten a copy of that.
That's correct, Your Honor. I'm sorry.
And you've reviewed it.
Yes, Your Honor.
This and you are
Brandon Bird, attorney for the Shane County.
all right. Very good.
Mr. Bird has also assured me that even if the case is dismissed because Mr. Bird is appointed, normally his representation would end at that time. He has assured me he will continue to advise Mr. Campbell about his 5th Amendment rights and appear at any trial as necessary.
That's correct.
Today is what the. All right, and I have signed the immunity order
Thank you, Your Honor.
for Mr. Campbell after reviewing the application in case. All right. Mr. Lacey?
Sir.
You're intending upon waiving your right to have a preliminary examination?
Yes, sir.
Okay. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed.
Yes, sir.
You understand you'll not now have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
All right. People also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on all 3 counts. Mr. Allen.
Thank you, Your Honor. We would waive any formal reading and stand mute.
And then having waived formal reading, standing mute to all 3 charges, court will enter a not guilty plea as to those charges. Pre-trial in this matter will be set for
January 7th at 1:30 with Judge Thomas.
January 7th, 2026, 1:30 before Judge Conlon.
Your Honor, we had this as a Judge Hamoud case.
You have it as a Hamoud. I also do have it as.
It may be due to the co-defendants.
I have his case. I have so Jones has Conlon and Mr. Lacey has Hamoud, and let me ask this. Your client, Mr. Elman, doesn't have any other criminal charge. Has he had any criminal charges in Washington County?
When was that was here, right?
Juguna.
As of many years ago, Your Honor, it doesn't, I don't believe he has
that's
pending.
fine. Were they felonies handled in circuit court?
I believe juvenile court, maybe, Your Honor.
Oh, okay, gotcha. When
So for Mr. Lacey, I have the years 2018 and 2019, which is what signed Judge Hamoud.
That would be, those are correct, Your Honor.
And
all right.
Mr. Jones's prior case, it's a more recent case, so they should go to Judge Hamoud.
They should go to trial.
That was what I was thinking.
That's what I was wondering. That's why I was asking, sir. I was trying to figure out, because you get a judge for life and then a co-defendant would follow along. So I was trying to figure out when any incident you had happened and when the co-defendant happened. All right. So Hamoud, date. This matter would be set January 5th, 2026, 1:30 before Judge Hamoud.
Your Honor.
Yes, sir.
My client would like me to briefly address bond. I know I've addressed bond previously in these matters.
Can I mean, I'll let you certainly address bond, but I think the thing, and whether or not your client would like the court to truly address bond, right now it's set at 150,000 cash surety. He now has added a life offense, which would change this significantly in the court's mind.
And I would request a no bond if bond is addressed.
And we're not going to address bond. Thank you.
Bond will continue.
May I approach to signing information?
Yes.
Should have one, I think.
I should have the new one. And
I'm pretty sure I did.
To speak, Your Honor.
Yes, sir.
For that Nolo.
Have I ever been able to stop you? but no, I appreciate you asking permission. Go ahead.
For that Nolo
Yes.
Price, are we going to call Mr. Campbell's case today?
He's here.
Yes. I was just going to file paperwork, Your Honor, but whatever please support.
What's your preference, sir? Would you like me to?
What's easier for Ms. Lundy?
It doesn't matter. I can just file the paperwork.
I mean, Ms. Filter, sorry.
Mr. Campbell's here.
Yeah.
So why don't we do it this way? We're still waiting for Mr. Perkins.
Yes.
And so why don't I just have that case brought down and we'll just take care of it on the record.
But he's not relieved of his subpoena obligation.
Correct.
Okay.
He would need to understand that.
Oh, no, we had a discussion
about that. Okay. And any dismissal anyway today would be without prejudice, so that if he doesn't fulfill those obligations, this case is going to come back up.
Correct.
But if you want me to call, I'll just get the file done and call it today. And clarify it.
Have a day, Your Honor.
You do the same, Stroman. Okay. So you're going to get that one down and then do that. And then do we have any clue as to where they might be in selection?
So they're having a hard time getting their last juror to stick. I was told 15 minutes and then I got now we got grab somebody else, so.
All right, so we'll get that filed out and then but they're on their last year.
Yes.
Okay, all right. All right, so then what I'm gonna do is I'm gonna then stand in recess and I'll come back out. Hopefully, once Mr. Perkins gets over, we can get everything lined up, take care of your case. Take care. All right, thank you. Court's gonna stand in recess. All right.
Well, you know, it's another day, another set of cases, and your old wolf is getting ready to sign off for the evening. Ladies and gentlemen, it's been a great pleasure serving you this evening. It's been a great pleasure bringing you some of the best cases of the day and compiling them and getting them all together. Always fun. I just want to really thank a group of people. Rhonda, thank you so much. 10 times over. Tori, 10 times over. Living like a cat. Thank you 5 times over. You guys make it all everything. And everybody. You know, I don't know words. I can't words because words are hard. And when you're trying to say words, they never come out the way you want them to. So I'm just going to say thank you, people. Thank you. And I hope you come back. Hope to see you again sometimes. It's been a wonderful stream. There'll be more tomorrow. Hope you come by. 8 o'clock Central Time, 9 o'clock Eastern Time. And we do these live things every single Saturday at noon Eastern to 11 a.m. Central. We'll see you then. I am your Lone Wolf Weasel. I thank you very much. Till next time, you'll have a very good evening.